Good morning, everyone, and welcome to this special legal compliance open public webinar run by Kaizen Synergy Law Firm. My name is Nihal Samara. I'm the General Counsel and Legal Director here at Kaizen Synergy, and I'd like to welcome you all to today's session. Today's session is an open session whereby we will run this webinar, and more than happy to open up the phone lines and recordings at the end of the session. Of course, if you are watching this webinar live as well too, you can obviously ask any questions in the chat group as we go through as well too. And of course, we will get to those as we move through today's session. All of the sessions that we do run are recorded all the way up to the question and answer part of the webinar, where we do open up the phone lines and stay online to answer any questions that people might have. You can also use the chat group as we go through. This is then published at the end of today's session directly onto the law firm's YouTube channel as well too. Here you will actually see all of the other webinars that we have run throughout the last 12 months as well too, and it will also be made available directly onto our website as well too. So with these particular sessions, as I mentioned, you can view those directly on our YouTube channel, which started playing just before, and also made available on our website. And any other resources can also be accessed directly off our Gemba 360 dashboard as well too. So you do have access to all of these resources, which we will make available today. That said, the pandemic laws that are now focused towards children, we are seeing these start to get a lot more traction by state and territory and Commonwealth governments, and also the media are starting to pick up on these as well too. So today's session is going to discuss some of these particular requirements. We are going to focus on the rules that affect children. We're going to discuss consent around these as well too, and some of the challenges that your agencies who provide support services to children, minors, then what do you actually need to do, and what do you need to be aware about this as well too. So we will be covering all of these off. As always, we'd like to pay our respects to the elders past and present upon the lands on which we all meet. While this session is being run by webinar and recorded, we do pay our respects to the traditional owners from where you all join us today. So essentially, when we look at COVID vaccine and children, we see that in the news, this is starting to build up across the news and media outlets. We're seeing the talk that COVID vaccines for under 12s will be delayed until 2022, and a number of different newspaper articles that you can see in front of you, just a sample of what we've seen starting this month, have already started to flag that this is where the governments are moving to. Our law firm's position is to provide you with unbiased information. It is really not our position to discuss whether this is right or wrong around it. I know that there's been a lot of, and we acknowledge the volume of demonstrations that have been going around the country about pandemic laws. What we are doing simply here is to provide you with the current context of what's going on and potentially where this is being led to as well too. So the framework and the context of where we are heading into is that with almost 60% of children aged between 12 to 15 now fully vaccinated against COVID, the focus is turning to younger age groups. As of November 16, there has been almost a total of 27,000 cases in Australia among children aged 0 to 9. And data from the first 8 months of this year, and this was taken from the ABC, this year shows that 2.5% of them were actually hospitalised. That said, while children under 12 remain unvaccinated, they could also potentially spread the virus to others, particularly to vulnerable people in the population as well. So this is kind of the framework that we're seeing that governments are approaching this lens with. Now, there are a range of current laws that do affect children. So if you are aged 12 years or older, you can book a COVID-19 vaccination. What we are finding, though, is in some states, and like the bill that's currently in Victoria at the moment, that is being debated, the Public Health and Wellbeing Amendment, or what is titled as the Pandemic Bill in Victoria, is that this is starting to potentially impact or has an impact on children and the directions of pandemic laws. One such item that's listed in this pandemic bill includes that the pandemic orders, should this bill become law, may be expressed to apply to either all persons, a specific class of persons, or a specific group of persons as well too. But it must not be expressed to a single named individual. And in this case, what we're seeing is that this can be clearly interpreted to apply directly to children under the age of 12 and in a specific category as well too. What we're also seeing is that under the explanatory memorandum of the bill as well too, it does actually amend the Children, Youth and Families Act as well too. And one such part is for children that are actually in detention as well too, where the amendments under the public management bill could allow would allow the secretary in determining whether or not to give a person who is in isolation access to the outdoors and undertake outdoor recreational activities, and to have regard to any relevant pandemic order that is defined. So you can actually see the restrictions that can be placed, and this is not under just a state of emergency, but essentially under a ongoing piece of legislation that the secretary essentially could, the department secretary could actually determine unilaterally whether or not to give effect to an entire person in isolation access to the outdoors or even undertake outdoor recreational activities. So you can actually see that the limitations around this pandemic bill specifically is very, very far reaching, where it does actually change other pieces of legislation and essentially giving unilateral decisions to specific bureaucratic positions and also the Premier at the time as well too. So now that we're moving into these types of pandemic legislations and we're seeing these similar bills implemented around the country and raised for discussion around the country in different parts of other states and the likes. Now, essentially, when we look at COVID and COVID vaccines, what we're looking at, and we're going to focus a lot on this, is around consent. So essentially the news that 12 to 15-year-olds are offered COVID vaccines has led to a commentary about consent here in Australia and also around the world. Now, there is a degree of surprise from the public that children aged under 16 might be able to actually make their own medical treatment decisions. And this does actually relate to the COVID vaccine as well too. But this position has actually been around for a number of years, actually well before COVID. So essentially what practitioners may start to talk about, and for agencies delivering youth and other family support services, is now this potential split. And when I say potential split, services that children or people under the age of 16 may approach your service, but your service may also now need to look at very carefully going into 2022 how it actually manages this information and manages their information. And what I mean by this is essentially children under the age of 16 can have the ability to make their own decision to accept medical treatment that is actually offered to them. And this is allowed if the practitioner offering the health service assesses that the child understands the information relevant to that decision and has the maturity to weigh it up and reach a decision. And this is often referred to as Gillick competence, named after the legal case in the UK, but is often simply known as the mature minor. So a child that provides a practitioner with and shows that they can actually weigh up the relevant information and has the maturity to weigh it up could actually, I'm going to say separately to the parent, actually make a decision on their own. And this is actually current law as it stands. Now, essentially and I'm going to jump through these slides around this, and we might go back and forth a little bit, depending on the questions that people have, and I can see a few being raised around this. So the same child might be able to have the ability to make one decision, but not another. And this can become very tricky and confusing. So the child, for example, may make a decision whether to take Panadol, for example, but might not have the ability to make a more complex decision, for example, to undertake chemotherapy. And that is two quite, I'm going to say, dramatic examples of a medical treatment. But I'm just outlining how different this could actually be. And so essentially, if a child, and I'll jump to this, if a child does not want their parents to know about their choice and has been assessed as having the ability to choose for herself or himself, their parents may not be entitled to be consulted by the practitioner. So agencies like yourselves, as we're moving down into governments actually raising the pandemic laws and starting to look at directives on consent for children. Essentially, clinicians might be able to encourage a child to involve their parents, but ultimately the child's decisions must be respected on its own as well too. So essentially what we're seeing here is quite a shift, and this is for agencies, as I mentioned, that are providing support services. It might be refuge services for families. It might be support services under family violence protection orders and support services. It might be community service organizations. It might also be services that you're delivering to support children who are requiring care under the NDIS and the likes. Might be also different cultural backgrounds as well too, even around also considering Aboriginal and Torres Strait Islander backgrounds as well too. So essentially this is going to become very complex very, very quickly. You can have a situation going back now, if we look at these as well too, essentially looking at the Gillick competence or mature minor. If the assessment at the moment is that a child may decide on their own whether to accept medical treatment or not, then potentially as well too, if a family member comes in to have a medical practice service and you're aware of it, then essentially your staff will need to consider whether the child should be on their own, whether they're expressing a different view based on what their parents' directions are. And we can now see that essentially there are groups of people that are opposing already the vaccine, and it may well be likely that situations are occurring whereby children are not opposed to the vaccine, but their parents are, or vice versa, where a parent may be pro-vaccine, but the child actually isn't. So essentially, there are a number of different components here, but essentially what it's coming down to is essentially whether the child has the understanding to demonstrate the understanding of what the relevance of this decision is, and also the maturity to weigh it up and also reach a decision too. Essentially, when we're looking at this, essentially what we're seeing is that all this reflects, and what any parent actually does know, is that while the law requires there to be a clear cutoff point between childhood and adulthood, in real life, that is simply not as straightforward as that. And there is a balance that needs to be struck as the child grows up between protecting them from harm and also letting them make their own choices, whether actually in relation to healthcare or anything else. This obviously then flows into other cultural decisions as well too, and cultural backgrounds that you will see as well. And this is where we look at, and this crosses over into the law of ethics as well. Under the APRA guidelines, essentially there is a code of conduct for all registered health practitioners. And essentially practitioners need to obtain informed consent for the care that they provide to their patients or clients, and caring for children and young people brings additional responsibilities for practitioners. So around the world, what we're seeing is that ethical guidelines are consistent in the sense that they look at whether a young person under 16 may have the capacity to consent, depending on their maturity and ability to understand what is involved. This is going to become very complex when you start to introduce COVID vaccines for people under the age of 16. So essentially, practitioners must decide whether a young person is able to understand the nature, purpose, and possible consequences of investigations or treatments that you are proposing, or whether essentially they are able to retain and use and weigh this information and also communicate their decisions to others in terms of providing that consent of the investigation or treatment. And essentially, it will resolve back onto your practitioners to ensure that you must make sure that all relevant information has been provided and thoroughly discussed before deciding whether or not a child or young person has the capacity to consent. So Maurizio, and I will just jump to this, Maurizio has just asked a question. At the end, it will be the sole decision of a clinician to determine whether a child is mature enough to reach such a decision. Maurizio, that is, Maurizio, in part that is correct around that. But essentially what we are saying is that while the clinician has the decision, it will also be whether the child actually decides to actually, I'll call it, invoke their decision in order whether to have it or not as well too. So essentially for agencies providing community health-based services, and as I mentioned, quite complex services where we're not looking at this simply as a linear type of a sole decision. It may also be other considerations that you also need to consider. So essentially, in the context of COVID vaccines, parents and under 16s should be provided with relevant information to enable them to make an informed choice. And essentially, when you look at these types of guidelines that that APRA and other government agencies, policymakers have put up, they talk about the COVID vaccines and relevant information being provided in order to make an informed choice. What we are seeing, though, quite clearly is even as adults, there is a lot of information out there, and there is a lot of discussion in terms of whether the vaccines and the information that is considered to be relevant is not clear in terms of what information should actually be given. And so some of these guidelines, and why I raise this now leading into 2022 for a lot of your agencies, is to actually start to consider, well, how are we going to manage this choice and provide support to our clients that we are delivering services to. Noel has just raised, which I will come to, so the clinician is the person who makes the decision as to whether the child is able to provide consent. this is the same clinician who gets paid for each vaccine they deliver. Surely this is a conflict of interest and could be legally challenged by the family. Essentially, Noel, there are a number of points that you raise around this as well too. So essentially, the vaccine that the clinicians are charging, again, under, which I will just sort of mention, under Medicare, to put it into context, whether they are actually delivering a service. It is a consult, so whether you go in for a cough or a cold or a longer consult, it is based on the length of the consultation initially that is being provided as well too. There are obviously, which you have recognized, other things like Medicare items for different consults and the likes around it, but essentially it is the guidelines issued for not just around vaccines, but essentially for any medical treatment being provided by practitioners. And this is not just under medical practitioners, obviously around the vaccine, but this is all other medical, practitioners registered with the Health Registration Board as well too. But as I said, this is essentially a review of the current standing of the current legislation and laws to inform you about. Obviously, these discussions that we will have, we are going to be looking at running further information sessions around these and looking at policies to support your agencies and the likes. The most obvious, going back to the session, the most obvious will be to identify the clear risks and benefits of having the vaccine for a particular child, so that child can be given the information that they need to make an informed choice. And picking up Noel's point, the idea is that practitioners, irrespective of whether it is about the vaccine or some other medical treatment, as I mentioned about for the likes of taking Panadol or having chemo, essentially the practitioners need to demonstrate that they can show what the risks are and that the client or the child in this circumstance is understanding what those risks also are as well too. The information might be different depending on which vaccine is being offered. The child will also need to know about the risks of not accepting the vaccine so that the options can be weighed against the other as well too. The long-term risks of any COVID vaccines are not known for certain, and nor are the long-term implications of having COVID. So those uncertainties themselves will also need to have been taken into account as well. What is important here is that what we call sufficient information must be provided, so that under 16s and their parents will need to be informed about relevant non-medical factors, such as the risks of having to miss school if they catch COVID, and the risk of passing on COVID to their friends and family as well too. Essentially, under 16s concerned with the vaccine should be sent to those parts of the world where adults who are particularly vulnerable with COVID have not been vaccinated, rather than use healthy children, essentially, is what is being considered. So even if a child is assessed as not having the ability to make the ultimate decision about the vaccine themselves, they should still be provided with information about it, should their wishes need to be taken into account. And of course, as part of this, cultural awareness is key to also to consider different cultural awareness backgrounds and also considerations as well too. We will open up the phone lines. I can see a lot of questions coming through around this, but if you are watching this webinar after today's live session, by all means, please and you do have any questions around this, by all means, please contact us on 1300 360 360 or email us at support@gemba360.com.